Thank you, Mr Speaker.
I call Andrew Little.
Thank you, Mr Speaker. Mr Speaker, once upon a time I would have said, when you don't have an argument, you resort to ad hominem attacks, you avoid the issues, you don't talk about the bill, and you talk around it, and you shout and you carry on and you abuse everybody. Now I have synthesised that into a new argument, especially for this national government. When you don't have an argument, you put David Bennett up to speak, because he has never made a constructive contribution to a piece of legislation in the admittedly comparatively short time that I have been in this House. And that last speech was, frankly, a shocker. And the people of Hamilton, east or west, north or south, in fact, will be dreadfully embarrassed. Those who are tuned in this afternoon, anxiously sitting over their wireless sets, wondering what their highly paid local member is saying in their name and on their behalf, and they will be sitting there, their stomachs turning, their noses turning up, their lips dripping with even greater anxiety and concern than ever before. And that is the disappointing thing about it. Mr Speaker, this bill has its genesis in the chartering on commercial terms of a seagoing vessel from Sri Lanka to Canada. It was a rather nice ship, well laid out. It carried about 500 Sri Lankans who felt as if they were being harassed in their own country, and they wanted to get out. And the Sri Lankan diaspora in Canada had chartered a vessel to convey them from one side of the Pacific to the other, and they washed up, or at least turned up, towed by a tug, no doubt, into the west coast, on the west coast of the great North America. And on that basis, this government, because of a representative in Canada, was frightened into believing that there was this mass market of people, citizens in other countries who were feeling harassed and put upon trying to flee their country, and that they would come to New Zealand. And in fact, that has never happened. Never happened here, and it didn't succeed in Canada either. And so, sir, this is a piece of legislation that has no basis at all. There is no evidence. And in the time I sat on the Select Committee considering this bill, we heard no credible evidence from anybody saying there was even an iota of risk that this mass arrival, as contemplated by this bill, would happen. And that is why we are so opposed to it, because it assumes the possibility of something that is virtually impossible, and then it grants extraordinary powers to immigration officials and to the courts to treat those people in a less than humane way. Here's what the Tracy Barnett, who is a well-known columnist for the New Zealand Herald, but also a board member of the Auckland Refugee Council, here's what she wrote in a recent edition of the Amnesty International newsletter, the New Zealand edition. She said about this and the approach under this bill, and I quote, "Detention will be more expensive, damage our international humanitarian reputation, and punish the world's most desperate, while doing absolutely nothing to deter traffickers. Not to mention one tiny confounding detail. New Zealand has never had a boat arrival of asylum seekers in modern history, and that's the reality of it. This bill isn't about remedying a known problem, it's about making something up and pushing political buttons in the Waikato hinterland and the chance that it might attract a few more votes. Here's the reality of this. Here's the reality. If 30 or more people turn up at an airport, or indeed on a boat, and they don't have the proper documentation, then an immigration official can go off to the district court and can apply for this mass arrival or mass detention warrant. And here's the thing. Here's why it fails the test of due process. The immigration official, and the immigration official alone, can swear the detail needed for the warrant, and they can assert that it is needed to manage the group of people, and a variety of other things. When it comes to the judge's hands are tied, and the judge has very few choices, because under the new section 317B, as it will be, in the amended Act. The judge must, if satisfied that matters specified, which I'll talk about shortly, if they are there in the application, the judge must grant the warrant. There is no discretion. And here's the more horrifying thing about it. The matters about which the judge must be satisfied are nothing to do with the substance of the claim, that they are asylum seekers, that they are seeking refuge from a country which they no longer wish to be part of. The judge simply has to be satisfied that the application is made on oath, well, that's easy enough, that the number of, about the number of persons to whom the application applies, well, that is a matter entirely dependent on what the immigration official says, that each is identifiable. They don't have to have identification documents, just that the immigration official can specify the number and each person. Must specify the particulars of the craft they came on. Was it a flight? Was it a vessel, a seagoing vessel? And a description of the circumstances in which they have arrived. And then the immigration official must state one of the reasons why they consider the warrant as necessary, and that is a matter of mere assertion. No evidence has to be supplied, it is a matter of mere assertion. And then must state how those bland criteria apply to each person. Once the judge is satisfied that that is all in the application, without any inquiry into the substance, without any verification sought by way of evidence, without any scope for challenge by any of the people who are the subject of the warrant, because they will be in no position to seek counsel and instruct them, or to make their own application, or to make a counter-application. The judge is dependent entirely on what an immigration official says. Once the judge is satisfied that that is all there, then the judge must grant the warrant. Must grant the warrant. And the scope for review and appeal is hugely limited. And upon granting of the warrant, we know exactly what will happen. They will be bundled up and they will be shipped down to Waihuru, or up to Waihuru, depending on where they've landed. Shipped to Waihuru. Why do we know this? Because, Mr. Speaker, we saw in the Customs Department newsletter last year that they have run an exercise. They have trialled this. They know exactly what they want to do. And they want to bundle them up, ship them off, and plant them in Waihuru, one of the most inhospitable parts of New Zealand. That's why we train our hardiest and our best military personnel there. And they want to plant them in there, who knows under what conditions, until the system is ready to deal with them. And they can be there for up to 6 months. And in fact, it may be longer because the warrants are renewable simply on restating and repeating the earlier application, again without evidence, again on the basis of mere assertion by an official. That's the basis on which this system will operate. It is a disgrace for New Zealand to now have this on our statute books. This will be an international embarrassment. And the Minister of Labour, who is shortly to go into an international forum next week, he will understand what it means to be internationally embarrassed. And he might take a little visit while he's at the Palais des Nations in Geneva and have a look at the committee room where they do the application, the human rights appeals and applications. It is a highly secure facility, and he will see the people who are there, who are represented there, because they are the dispossessed and the poor and the bedraggled and those who are degraded and those who feel stateless because they are. And this is the environment. This is the environment in which we are now playing, and we are passing this law, and we want to hold our hand up in international forums to which we belong, including the ILO next week, and wave our hand up and say we are a progressive, socially progressive, liberal democracy. This lends the lie to that. This is a disgrace for us, and members in this House will hang their head in shame, as the Minister of Immigration is right now, cannot look up, has to look down, as indeed the Minister of Labour is, as the Chief Whip is, the Chief Government Whip, all looking down because they know this is wrong. This is bad law, this is a bad statute, and it will go when a progressive Labour-led government takes the Treasury benches again.
I call Jan Logie.
Thank you, Mr. Speaker. The Green Party strongly opposes